Hi, I'm Philip Hurl. I'm the attorney for the Southwest Virginia Association of Realtors. An issue has come up in our area recently that I've received some questions about, and your association decided the easiest way for us to get the information out to answer these questions is through this video. I want to talk to you today about condominiums and resale certificates. The current version of the Virginia Association of Realtors form has a provision in it that asks if the property being sold is in a condominium development, and requires the purchaser to obtain a resale certificate from the association and the unit owner in order to make the contract enforceable. If this resale certificate is not obtained, the purchaser has up until closing essentially to back out of the contract. So it's a way for people to get out of the contract if you don't comply with this. On the other hand, if you don't comply with this and you make it through to closing, then everything is fine. From the standpoint of the contract being valid, the people cannot, after closing, come back and hang their hat on this in order to get out of the contract. It would not, however, affect the liability of a licensed real estate agent to a potential purchaser if they came in, they did not obtain the resale certificate, was not told about it by the licensed agent. They could claim that the agent was negligent in not providing them information that they should have had. So this is important. We're just now finding out, or these are just becoming issues in this area because, quite frankly, condominiums are not that common in this part of the state, but they are becoming more so. There's 4 or 5 developments in the Washington County and Bristol area now. There's some in Russell County that I'm aware of. So anytime that you list a piece of property and it is part of a condominium unit, then you're going to have to comply with these regulations in order to protect yourself. I should note that there is a difference between a condominium and a townhouse. And the difference is this: with a townhouse, you're actually getting grass. You own land, you own dirt when you purchase it. You can tell this from the plat. When you list a piece of property, if you see that the lines go to a street or to an alley, to a driveway, and the lines run down between the walls of each unit, then that means it's a townhouse. There will be a declaration, just like there is for a subdivision. When you get copies of restrictions for a home that's in a subdivision, there'll be similar documents for a townhouse, and all the wording will be townhouse as opposed to condominium. In the deed to the property, when you list it, it'll say townhouse unit such and such, or the plat will have the word townhouse in it. Townhouses are not governed by the rules that we're going to talk about today. They're governed by a completely different set of rules, and on those you essentially need to get copies of the restrictions and the recorded documents, just like you would in a subdivision that have restrictions to it. With a condominium, you don't own dirt. The dirt, the roof, all of the areas of the complex, other than the interior of each individual unit, is actually owned by the Unit Owners Association. It's owned by everybody in the development. You own the sheetrock in the unit, but you don't own the studs in the wall. You don't own the rafters. You don't own the roof. Sometimes you control the windows and sometimes you don't. It's different with each condominium. They can be set up differently. But it'll also have in the deed to the property that it is the word condominium, unit number such and such of such and such condominium. So that's how you know. If you're listing a piece of property that's in a condominium, then I'm sure there's a place in the, you would note that within the MLS to begin with, whether it is a condominium. And you should probably at the time of listing also obtain the information that we're going to talk about so that at least know where to get it. The information that you have to get, this resale certificate that you have to obtain, you probably won't get a copy of that or request that at the time that you list the property. The reason is the Unit Owners Association can charge for that. They can charge fees of upwards of $150 to provide that certificate to you. So it's not something that you would probably request at the time of listing. You would only request it at the time that the contract is signed. All the resale certificate is essentially a letter to whom it may concern, to the prospective purchaser, that provides certain information to that purchaser. In that letter, and there'll be a copy of a sample letter or a sample resale certificate posted on the association's website as part of this discussion. But in that letter, it's going to provide you with certain information. They're going to provide you with a list of any unpaid assessments for the unit in question. If you're selling Unit 3 of the Cross Creek condominiums, then that letter will tell you whether there are any unpaid assessments for Unit 3. It'll tell you if the association has approved any special assessments. There's two different types of assessments that you'll run across with a condominium unit. Regular assessments, those are usually paid on a monthly or quarterly basis. And then there are special assessments that are paid whenever the association's board of directors approves them. Special assessments are used for things like fixing a retaining wall, repairing a roof, re-roofing, fixing a parking lot, driveway with asphalt, things that are out of the ordinary. They are special, and they're called special assessments because they don't happen regularly. They come up when the situation arises within the complex. Most of the complexes that you're going to be dealing with in our area are not going to have special assessments at this time. They will have regular assessments, those. And those regular assessments cover things like the maintenance of the driveway, termite and pest treatments in the units. They pay the insurance that's on the units. With a condominium, the fire insurance for the dwelling itself is most always maintained by the association rather than the homeowner. The only insurance that a homeowner purchases with a condominium is going to cover their personal items that's within the unit and replace things like appliances and cabinets, things that are within the unit itself. The fire insurance on the structure that the unit is in is maintained by the association, and that bill for that insurance coverage is paid through regular assessments each month. Sometimes the assessments are only paid on a quarterly basis. It's possible that they could only be due annually. But whatever the special assessments are for a unit, those have to be listed in the resale certificate. Same thing with regular assessments. It will tell you in that certificate, that letter that you obtain from the association, that each month each unit owner has to pay $45 a month or $45 a quarter for regular assessments. The certificate will also tell you that whether there are any costs due to the association upon the sale of the unit. Some associations will assess a $50 fee so that they can change their records to reflect the new owner's name. If there's any fees or expenses that arise upon the sale of the unit, the resale certificate must state that. The resale certificate will list any fees that are due to third parties as a result of you owning the unit. For example, a condominium complex could have a contract with a pest treatment company, and that is not paid by the association, but each unit owner is obligated to pay $10 every quarter to such and such pest control in order to keep the units treated for wood destroying insects. So if there's any cost due to third parties on a regular basis, that has to be listed in the resale certificate.